typing is an essential after dictation. Try exam-oriented typing tests, check accuracy, number of errors, gain speed, and more. Complete the typing test in a given time. Read dictation materials. Subscribe to get contents via mail. Purchase shorthand journals and more.
The marriage between the appellant and the respondent number 1 was solemnized on 27/11/2005 and they lived as husband and wife. As the allegations proceed, there was demand of dowry by the husband including his relatives and demands not being satisfied. The appellant was driven out from the matrimonial home. However, due to intervention of the elderly people of the locality, there was some kind of conciliation, as a consequence of which both the husband and the wife stayed in a rented house for 2 months. With the efflux of time, the husband filed a petition seeking judicial separation before the family court, and eventually the said prayer was granted by the learned judge family court. After the judicial separation on 22/5/2010, the appellant filed an application under section 12 of the 2005 Act before the Child Development Protection Officer (CDPO), Office of the District Inspector, Social Welfare and Social Education, seeking necessary help as per the provisions contained in the 2005 Act. She sought seizure of Sridhan articles from the possession of the husband. The application, which was made before the CDPO, was forwarded by the said authority to the learned Chief Judicial Magistrate. By letter dated 1/6/2010, the learned magistrate issued notice to the respondent, who filed his written objections on 14/2/2011. Before the learned magistrate, it was contended by the respondent that the application preferred by the wife was barred by limitation and that she could not have raised claim as regards Sridhan after the decree of judicial separation passed by the competent court. The learned magistrate, taking into consideration the admitted fact that respondent and the appellant had entered into wedlock, treated her as an aggrieved person, but opined that no domestic relationship as defined under section 2(f) of the 2005 Act existed between the parties, and therefore wife was not entitled to file the application under section 12 of the 2005 Act. The learned magistrate came to hold that though the parties had not been divorced, but the decree of judicial separation would be an impediment for entertaining the application, and being of this view, he opined that no domestic relationship subsisted under the 2005 Act, and hence no relief could be granted. But it stated here that before the learned magistrate, apart from herself, the appellant examined 3 witnesses and the husband had examined himself as DW1. The learned magistrate, while dealing with the maintainability of the petition, had noted the contentions of the parties as regards merits, but has really not recorded any finding thereon. The aggrieved wife preferred criminal appeal number 6(1) of 2014, which has been decided by the learned additional sessions judge, holding inter alia that the object of the 2005 Act is primarily to give immediate relief to the victims. That as per the decision of this court in Indrajit Singh versus State of Punjab, that section 468 of the Code of Criminal Procedure applies to the proceedings under the 2005 Act, and therefore her application was barred by time. Being of this view, the appellate court dismissed the appeal. On a revision being preferred, the High Court, as is demonstrable from the impugned order, after referring to the decision in Indrajit Singh (Supra), has stated that the wife had filed a criminal case under Section 498A IPC in the year 2006 and that the husband had obtained a degree of judicial separation in 2008, and hence the proceedings under the 2005 Act was barred by limitation. That apart, it has also in a way expressed the view that the proceedings under the 2005 Act was not maintainable.